First, we heard yesterday Azerbaijan argue that much discussion between the parties, I quote, solely concerned Armenia's wish to include in the agreed procedural modalities a passage that would allow Armenia to prove, as a matter of fact, that negotiations had in fact failed. And that, somehow, according to Azerbaijan, detracts from the genuine character of Armenia's attempt to negotiate. This is false. Armenia did not make its proposals because it had the proceedings before the court at the forefront of its mind, as Azerbaijan argues. Rather, Armenia made its proposal, which Azerbaijan resisted strongly, because Azerbaijan sought to limit the parties' ability to rely on their diplomatic exchanges before the court. As Armenia wrote on 16 April 2021, already 5 months into the negotiations, Azerbaijan's proposals would gravely impair the ability of the parties to establish that there has been a failure of negotiations. Such consequence would contradict the state parties' aim to eradicate all forms of racial discrimination effectively and promptly. And as Armenia noted in its letter 4 days after that, Azerbaijan's insistence that the only manner in which these substantive negotiations can commence is at the expense of Armenia's rights under Article 22 speaks volumes about Azerbaijan's preoccupations at this stage. It is equally false for Azerbaijan to argue that Armenia did not genuinely negotiate the dispute because it did not allocate enough time for doing so. Counsel for Azerbaijan surmised that negotiations over such a substantial dispute should probably take months, if not years. By contrast, he argued, I quote, Armenia initially suggested just 1 day, with the second day held in reserve for possible further discussion. Counsel for Azerbaijan cites here to Annex 5 to Azerbaijan's preliminary objections, which is a letter from Armenia dated 22 January 2021. The letter, however, makes clear that Armenia was proposing 1 day with the second day in reserve for a first meeting. Armenia by no means assumed that the entire dispute would be settled within those 2 days. In fact, Armenia's proposed agenda, as an annex to the same letter, expressly provided for, quote, exchange of views on whether the dispute can be amicably resolved through further discussions. Counsel for Azerbaijan yesterday went on to say, I quote, Armenia in the end only agreed to a schedule that allocated 2 days for the presentation of its claims and requested remedies and gave Azerbaijan another 2 days to present its replies. 4 days in all, end of quote. But this too is misleading. Here, Council cites to Annex 42 to Azerbaijan's preliminary objections, which is a letter from Armenia dated 14 July 2021. But once again, Armenia proposed these 4 days for meetings without assuming that negotiations would end thereafter. In its very prior letter of 9 July 2021, Armenia expressly stated that it was open to additional discussions beyond those days of meetings. I move now to my third observation. Neither Article 22 nor international law requires Armenia to jointly with Azerbaijan declare the negotiations to have become futile. Armenia was happy to suggest that the parties jointly assess whether further negotiations are constructive in resolving the dispute in April 2021. It was not happy to do so in July, by June 2021, after seeing yet another 2 months being squandered away on Azerbaijan's dilatory tactics. And finally, it is false to assert that Armenia rejected Azerbaijan's proposals, I quote, outright without engaging with them. Armenia carefully considered these proposals for 2 weeks and explained at the 15 September 2021 meeting that they failed to address the claims it has presented to Azerbaijan and the remedies it had requested. And this brings me to Azerbaijan's last ground for its first preliminary objection, which is being asserted in the alternative, namely that Armenia, after 10 whole months, allegedly did not pursue negotiations as far as possible. Azerbaijan's argument is basically that Armenia did not allow Azerbaijan's position to evolve. But Armenia did afford Azerbaijan an adequate chance to reconsider its repeated rejection of Armenia's claims. Azerbaijan's proposals of August 2021 merely concerned proposed steps that Azerbaijan would take only if Armenia took them as well. Even then, the proposed actions were couched in tentative terms. Azerbaijan proposed to facilitate the return of the forcibly displaced, but did not allow it, as Armenia was asking. Azerbaijan proposed to take steps to provide equality before the law, but did not guarantee it, as Armenia was asking. Azerbaijan proposed to assess educational materials, but refused to adopt immediate and effective educational measures, as Armenia was asking. Azerbaijan proposed to consider the removal of racist depictions at the military trophies park, but did not remove them, as Armenia was asking. Armenia's memorial submissions make clear that Armenia seeks from the court declarations that Azerbaijan has breached the CERD, and in order that Azerbaijan shall cease these breaches, offer assurances and guarantees of non-repetition, and make reparation by way of restitution and compensation. Azerbaijan's proposals, on the other hand, contain no acknowledgement of any wrongdoing, and of course, no provision of remedies. As I noted earlier, Azerbaijan's proposals merely called for joint steps to be taken without any particular further indication as to the time frame of implementation or anything else. But concrete steps needed to be taken immediately, and steps that were in Azerbaijan's sole power to take. Throughout its supposed genuine engagement in amicable settlement, Azerbaijan was in fact aggravating the dispute, thereby compounding the harm and Armenia's necessity to act. As early as 22 December 2020, referring to the scale and severity of Azerbaijan's ongoing violations, Armenia asked that negotiations be conducted promptly and in good faith. On 22 January 2021, Armenia reiterated the urgent need to protect ethnic Armenians from Azerbaijan's ongoing discrimination, including the torture and murder of civilians and hate speech emanating from the highest levels of government, and expressed its regret that the parties had not yet been able to meet 2 months after the commencement of the negotiations. On 2 April 2021, Armenia recalled the seriousness and ongoing nature of Azerbaijan's breaches of the Convention and the imperative need to bring them to an immediate end, expressing the hope that Azerbaijan will confirm the agreed scope of negotiations so that substantive discussions can proceed. And that did not happen until 2 months later. On 20 April 2021, Armenia specifically referred to Azerbaijan's decision to open the military trophies park, recalling the need to maintain a constructive atmosphere in the negotiations. At the meeting of 31 May 2021, Armenia reiterated once again its great concern that the military trophies park, as well as Azerbaijan's recent widely condemned incursion onto Armenian territory, negatively affect the atmosphere of negotiations and risk undermining their progress. And on 22nd of June 2021, Armenia noted that while within the framework of these negotiations, Azerbaijan professes an intent to maximize the prospect of resolving the dispute, outside that framework, it has acted to exacerbate its violations, including by opening the military trophies park. What was Azerbaijan's response, you may wonder? To deny and double down on its claims. And what made it finally remove the racist mannequins of the military trophies park? The threat of provisional measures by the court. Azerbaijan argues that negotiations do not mean that one party simply submits to the demands of the other, and we agree. Armenia was not obliged to accept proposals that it did not consider adequate, in the same way that Azerbaijan was not obliged to accept Armenia's claims and requested remedies. But this is why Article 22 vests the court with jurisdiction over this dispute. Mr. President, distinguished members of the court, Armenia, of course, acknowledges that the court has not yet ruled on the merits of its claims. But it is a fact that Azerbaijan has been the subject of 3 provisional measures orders and 2 affirmations of provisional measures, setting a most notorious record in the jurisprudence of the court. The fact that the court has indicated so many provisional measures against Azerbaijan in less than 2.5 years makes indisputably clear that Armenia's wish in resolving this dispute without undue delay was entirely warranted. Again, we recognize that the court has not yet ruled on the merits, but to call Armenia's conduct in bringing this case premature is very unfortunate and disrespectful to the thousands of victims of Azerbaijan's conduct, some of whom it purports to consider its citizens. The upshot of all this should be clear by now. Armenia genuinely engaged with Azerbaijan throughout the entire negotiations. Armenia accommodated Azerbaijan's request to discuss its claims alongside Armenia's. Armenia accommodated Azerbaijan's request to first discuss modalities. Armenia accommodated Azerbaijan's request to then discuss the scope of the negotiations. And Armenia yielded to Azerbaijan's proposals on the schedule and format of presentation of claims. But all this was met with rejection upon rejection, mirroring, dilatory tactics, and aggravation. Still, Armenia put an end to the negotiations only when it became evident that Azerbaijan would never acknowledge any wrongdoing or remedy its violations. That is, after more than 40 pieces of correspondence, 7 rounds of bilateral meetings, and 10 months of negotiation. There can thus be no question that Armenia fulfilled the negotiation precondition in Article 22 of the Convention, and therefore Azerbaijan's first objection to jurisdiction must be rejected. I thank the Court for its time and attention, and I would kindly ask, Mr. President, that you give the floor to my colleague, Professor Pierre Darzan.
I thank Mr. Salonides for his statement. J'appelle maintenant à la barre Monsieur le Professeur Pierre Darzan. Vous avez la parole.
Merci, Monsieur le Président.
Thank you very much, Mr. President. Mr. President, Madam Vice President, members of the Court. It's an honor to appear again before the Court on behalf of Armenia. I shall attempt to limit the subject matter of our Azerbaijan's second preliminary objection because it does not concern all of Armenia's claims, and as you know, it was recently amended. Secondly, I shall come back to the context of the claims submitted to you, as this is decisive for a proper understanding of this objection. Lastly, by way of introduction of my colleagues' pleadings, I shall briefly outline the Court's substantive jurisdiction, and I shall examine their application with regard to the Convention. Mr. President, as modified, Azerbaijan's second preliminary objection only aims to exclude some of Armenia's allegations of a violation of the Convention from the debate on the merits, namely, on the one hand, allegations relating to arbitrary detention of ethnic Armenians. Furthermore, allegations concerning the enforced disappearance of ethnic Armenians. And lastly, Armenia's claims regarding various exactions committed against ethnic Armenians. In that respect, Azerbaijan's position, as you know, apparently evolved during the proceedings. The question is, however, whether it has really changed, as it is difficult to know precisely what has changed. Firstly, Azerbaijan contended that the physical acts of violence against ethnic Armenians, irrespective of whether they were members of the armed forces or civilians, were to be ruled out of the material scope of the convention, in particular when those acts were committed by members of its armed forces. On the 5th of April, Azerbaijan stated that it no longer objected to the court's jurisdiction with regard to Armenia's claims relating to, and I quote, the mistreatment of ethnic Armenian civilians during armed conflict. All whilst maintaining its objection with regard, and I quote, to the remainder of Armenia's third claims related to alleged mistreatment of civilians during the active hostilities phase of armed conflict, in relation to which Armenia has presented no specific evidence of purported misconduct on the basis of ethnic or national origin. Moreover, Azerbaijan has maintained its objection concerning, and again I quote, claims relating to alleged mistreatment of Armenia's armed forces during the active hostilities phase of armed conflict. The specific contours of what remains of Azerbaijan's preliminary objection in that respect are, however, very vague. In fact, a distinction apparently needs to be made between the exactions against ethnic Armenians during the armed conflict and those which occurred during the active phase of hostilities of armed conflict. But yesterday's pleadings did not shed any light on the matter. Admittedly, Azerbaijan provided some details concerning dates with regard to what it considers to be the various active phases of hostilities between the parties. However, although this criterion may well be relevant, we fail to understand why it maintains its objections regarding arbitrary detentions and enforced disappearances which occurred outside the active phases of hostilities. Besides, what is meant by Armenia's armed forces? Is there a difference with Armenian military personnel, or again with Armenia's armed forces personnel, bearing in mind that there is civilian personnel in all armed forces? Azerbaijan is also focusing more broadly on the combatants in the active hostilities phase of an armed conflict. The statement no doubt includes the members of the armed forces of Armenia, but does it also concern civilians from Nagorno-Karabakh who joined the ranks of the separatist forces? Be that as it may, Azerbaijan's objection materia never concerned a large number of Armenia's claims, and you will find that in tab 1 of the judge's folder, which essentially reproduces paragraph 36 of Armenia's written observations. Although Azerbaijan's second preliminary objections concerns a series of acts which occurred at the time or following the hostilities between the parties or during the active phase, the applicability in principle of the convention in times of armed conflict is not disputed by the respondent. This is an important point which Professor Murphy will revert to. Immediately after making this concession in principle, Azerbaijan nevertheless contends that certain acts which occurred at the time or following hostilities or during their active phase were in no way likely to engage its responsibility under the convention. In Azerbaijan's view, certain acts linked to hostilities which Armenia complains of and in respect of which no preliminary objection is based, some of these are not capable of being discriminatory under the convention, essentially, but not solely, having regard to the moment when they occurred, active or non-active phase of hostilities, or the victim's status, civilians or servicemen. According to Azerbaijan, to decide otherwise would amount to transforming any armed conflict between states into a conflict falling within the scope of the convention, because it is not unusual that wars are waged between people of different ethnic origins. Mr. President, members of the court, The distinctions in which Azerbaijan gets lost are absolutely irrelevant and meaningless with regard to the Convention, and they are all the more meaningless given that the conflict waged between Azerbaijan and the ethnic Armenians when they lived in Nagorno-Karabakh has very marked ethnic origins and dimensions. Yesterday, Azerbaijan acknowledged that the conflict submitted to the court is, and I quote, an ethnic conflict. Thus, this conflict is not an ordinary interstate war, unlike what Azerbaijan is submitting in a perfectly contradictory and decontextualized way, alleging that within this very conflict there are allegedly particularly cruel and shocking acts of violence, differences in treatment in breach of the equal enjoyment of fundamental rights, which nonetheless would have nothing to do with the ethnic origin of their victims. This conflict is an ethnic conflict as, under the guise of territorial integrity, for 3 decades, Azerbaijan has refused the self-determination of Armenians living in their ancestral hopeland of Nagorno-Karabakh and brought it to an end, to a brutal end. What Azerbaijan, in the words of its president, calls its war of liberation or patriotic war, resulted in many discriminatory violations of ethnic Armenians, including when they took part in the hostilities. Furthermore, this war resulted in a complete ethnic cleansing of Nagorno-Karabakh in disregard of the court's orders. According to its own national narrative, Azerbaijan allegedly freed itself by waging a war at the end of 2020 and then, in fact, through the gradual strangulation of Nagorno-Karabakh until the blow which was struck in September 2023 when the ethnic Armenian inhabitants were driven out of Nagorno-Karabakh. There you are. That is what is aimed at. A homeland devoid of ethnic Armenians. Need we say more? Not only with regard to the context of the dispute Armenia submitted to the court, but with regard to the very subject matter, which clearly falls in the ambit of the Convention, and that holds true for all of Armenian claims. Indeed, these concern violations of fundamental human rights, specifically because of the Armenian national ethnic origin and not because of their nationality or any other ground under the Convention. Members of the Court, I could stop there, not without adding, nonetheless, that it is the same obstinate refusal by Azerbaijan to see discriminatory evidence at the heart of its political and military plan and of its acts, which inevitably hastened the breakdown of the pre-litigation negotiations between the parties. To that end, it is sufficient to understand the full implication of Azerbaijan's second preliminary objection to reject the first, if you have not already been convinced that it is totally unfounded, as Maître Salonis demonstrated.
Monsieur le Président.
Mr. President, Azerbaijan's second preliminary objection is not only absurd, given the all-too-familiar general context in which all the facts complained of by Armenia occurred, and given the subject matter of the dispute before the court, but is also erroneous in terms of the conditions that determine the court's jurisdiction, ratione materiae. These conditions are well known. It must be ascertained whether the actions or omissions of the respondent complained of by the applicant fall within the scope of the treaty allegedly violated. In other words, whether the facts at issue, if established, are capable of constituting violations of obligations under the treaty. At this stage, 2 things are essential. First of all, there is no need for the court to satisfy itself that the measures of which the applicant complains actually constitute racial discrimination within the meaning of Article 1, Paragraph 1 of the Convention. Secondly, the facts should be considered as such by assuming that they're established. At this stage, it is not a matter of assessing the evidence that has been produced or to ask for more evidence. Thus, it is totally unnecessary at this stage to delve into linguistic exegesis or to assess the significance of certain statements, as Mr. Wordsworth did yesterday. It is just as incorrect to contend that Armenia allegedly did not provide sufficient evidence at this stage, because it is impossible to reach this conclusion without examining that evidence, and that can only be done at the merit stage. Thus, declaring at this stage what can or cannot be admissible as evidence produced by Armenia is inappropriate at this stage. And as my colleagues will demonstrate, there is no shortage of evidence. Azerbaijan contends that it is unlikely that the possible different treatment complained of by Armenia, and that is the subject matter of the second preliminary objection, is based on race, color, descent, or national or ethnic origin. It is not contested, however, that ethnic Armenians represent a protected group under the Convention. Furthermore, it is clear that among the specific obligations in relation to the treatment of individuals on the basis of race, color, descent, or national or ethnic origin, there is notably an obligation in Article 5 of the Convention to ensure, without any discrimination that is prohibited, the enjoyment of, and I quote, the right to security of person and protection by the state against violence or bodily harm, whether inflicted by government officials or by any individual group or institution. There is also an obligation to ensure non-discriminatory enjoyment of the right, and I quote, the right to equal treatment before the tribunals and all other organs administering justice. As my colleagues will demonstrate, the violations that Armenia is complaining of and that Azerbaijan would like to exclude from the substantive discussion are related to the treatment inflicted by Azerbaijan on ethnic Armenians and Armenian nationals in breach of these obligations and others in the Convention, including when the victims have taken part in the hostilities. By applying the same reasoning as the court's reasoning in its 8th of November 2019 judgment in Ukraine versus Russian Federation, we can conclude that the measures complained of by Armenia are capable of having an adverse effect on the enjoyment of certain rights protected under CERD, and insofar as they fall within the provisions of the Convention. Yet, Azerbaijan argues that because the facts complained of by Armenia occurred in circumstances of armed conflict, this would necessarily imply that the reason for this difference in treatment could not have been that the victims were ethnic Armenians, in which case these facts would not fall within the scope of the Convention. According to Azerbaijan, if the violations complained of occurred during the active phase of an armed conflict, there is a kind of a reversal of evidence, so to speak, because it now needs to be demonstrated that these violations cannot be explained by the circumstances, and therefore something more needs to be done or to be proved. Azerbaijan's position is wrong for three reasons. First of all, this position is based on the premise that because IHL applies in times of armed conflict, breaches of the Convention could only be additional or even secondary compared to breaches of the law of armed conflict. This notion is incorrect because both these sets of rules apply simultaneously when their respective conditions of application are encountered or are met. Contrary to what was argued yesterday, Armenia is not making claims based on international humanitarian law, to which it has added claims falling under the Convention. Furthermore, Armenia's claims under the Convention do not replace claims that it should have made under international humanitarian law instead, as Azerbaijan implies. Furthermore, let me recall that at this stage, it is only necessary to examine if these claims that are made by Armenia violate that are likely to breach the obligation of the Convention in such a way as to fall under its scope as defined by Article 1. The purpose here is not to reach a definitive conclusion on the existence or not of racial discrimination. And indeed, even if, quod non, the differences in treatment complained of could also be due to reasons not provided for by the Convention, they would still not fall outside its scope. Indeed, nothing in Article 1, Paragraph 1 of the Convention indicates that for discrimination to be based on a prohibited ground, it is necessary for this ground to be the only ground for the motivation or explanation of that discrimination. Such a conception would considerably narrow the scope of the Convention and would thus contradict its object and purpose, which is to speedily eliminate racial discrimination in all its forms and manifestations. Indeed, as the Court has held, and the parties have agreed, the Convention does prohibit no other reason for discrimination apart from race, color, descent, or national or ethnic origin. But we are not adding an additional ground for discrimination on the Convention if we consider that grounds that it does not provide for can coexist for the same different treatment with grounds that the Convention prohibits. Further, very often, in fact, a discriminatory measure based on a ground that is prohibited will follow other grounds that are not covered by the Convention, without the initial ground falling outside the scope of the Convention. The committee says precisely that in its General Recommendation number 32 by underscoring that double or multiple discriminatory situations can exist. Armenia is reading of the General Recommendation is not that it extends the grounds for discrimination prohibited under the Convention. And the Court's most recent jurisprudence confirms this point. In its judgment of 31st of January last, the Court recalled that any measure whose purpose is a differentiation of treatment based on a prohibited ground under Article 1, Paragraph 1, constitutes an act of racial discrimination under the Convention. Therefore, in substance, the Court has not required that differentiation in treatment should be based exclusively on a prohibited ground. In this case, it is undeniable that the purpose of differentiation of treatment complained of is perfectly likely not to be unrelated to a prohibited ground under the Convention. Finally, and precisely on this very point, Azerbaijan is mistaken in arguing that an additional specific burden of proof falls on Armenia and that it is not met because in this case it is mere collateral or secondary effects on persons who are distinguished by one of the prohibited grounds, and that it is well established that such effects do not, in and of themselves, constitute racial discrimination within the meaning of the Convention. Azerbaijan is mistaken because this question only arises in the case of indirect discrimination, that is to say, discrimination that is prohibited by the Convention depending on its effects. However, Armenia claims that of the subject matter of its preliminary objection fall under direct discrimination. The facts presented by Armenia, facts that the Court at this stage should consider as established, are perfectly likely to fall within the ambit of the Convention under direct discrimination, that is to say, discrimination resulting from a measure that seeks to make a differentiation in treatment based on a prohibited ground whose purpose is to deprive victims of equal enjoyment of their fundamental human rights. Members of the Court, the criteria for the Court's jurisdiction ratione materiae are clearly and perfectly met. Mr. President, I would like to thank you for your attention. I'd like to thank the Court for its attention, and I would like you to invite Professor Sean Murphy to take the floor. Thank you very much.
Mr. Darjean pour son intervention, and I now invite Professor Sean Murphy to take the floor. You have the floor, sir.
Dankjewel. Thank you, Mr. President. It's a great honor to appear again before the Court on behalf of Armenia. I will be addressing two considerations that are applicable to all of Azerbaijan's objections ratione materiae. First, I will explain why our claims to which Azerbaijan objects fall under the SIRD, even if they may also implicate international humanitarian law, which I will refer to as IHL. Second, I will address why the general Armenophobia that has been espoused and cultivated by the government of Azerbaijan is a relevant factor for the court at this jurisdictional stage, specifically for determining whether particular acts at issue are capable of violating the CERD. Turning to my first point, Azerbaijan says that the claims to which it objects have nothing to do with the CERD, but only involve alleged misconduct during armed conflict. As Professor Darjan just noted, the exact scope of Azerbaijan's second objection has become quite unclear. But whatever the precise contours of that objection, the heart of it seems to be the following. Azerbaijan insists that the claims to which it objects are governed by IHL and only by IHL. The central problem with this argument is that when assessing the acts of violence, arbitrary detention, or enforced disappearance at issue, whether they are capable of falling within the CERD, it is completely irrelevant if or when or how IHL applies to those acts. Indeed, Azerbaijan attempts to draw IHL-based distinctions, such as between soldiers and civilians, or between periods that do or do not involve active hostilities, but those distinctions are entirely meaningless for purposes of the CERD. The court simply need not address such issues. Rather, the court's jurisprudence makes clear that even if IHL applies, that source of law does not displace the CERD. In the nuclear weapons and Israeli wall advisory opinions, the court found that the protection offered by human rights conventions does not cease in case of armed conflict. And this remains true in the specific context of the simultaneous application of IHL and the CERD. Indeed, despite Russia's argument that a considerable part of Ukraine's claims in the financing of terrorism CERD case were really claims arising under IHL, the court had no difficulty at the jurisdictional stage in finding that the measures of which Ukraine complains are capable of having an adverse effect on the enjoyment of certain rights protected under CERD, and therefore that the measures thus fall within the provisions of the Convention. Azerbaijan, as it must, concedes that these two areas of international law operate in tandem. Azerbaijan says, and I quote, "CERD applies in armed conflict as well as in peacetime, and acts of war may implicate CERD if they impair the fundamental rights of individuals or groups of individuals based on their ethnic origin or other grounds enumerated in Article 1.1 of CERD." Mr. Wordsworth reaffirmed this yesterday when he said the CERD can apply in armed conflict as well as in peacetime. Azerbaijan's position, therefore, is not that acts relating to armed conflict are incapable of violating the CERD. Rather, Azerbaijan's position is that the particular facts that we have placed before you in this case, even if accepted as true, are incapable of violating the CERD. Thus, the only issue before you at present is whether the acts underlying Armenia's claims are capable of violating the CERD, even if they also separately violate other sources of law. As my colleagues in the following presentations will demonstrate, they clearly are capable of doing so. Mr. President, allow me to make two additional comments on this point. First, it is worth pausing on what Azerbaijan appears to be asking of the court. As Ms. McDonald will discuss further, Azerbaijan apparently is seeking from you a ruling that any violent abuse by Azerbaijan of ethnic Armenian soldiers connected to hostilities, even if undertaken in conjunction with extraordinarily hateful and vile racial rhetoric, is utterly incapable of violating the CERD. That cannot be right. It cannot be right that the CERD has nothing to say about an ethnic Armenian serviceman lying wounded on the ground, being shot in the head multiple times by an Azerbaijani soldier who is yelling an expletive against what he refers to as your people. In the face of such evidence, the notion that this violent abuse of ethnic Armenian soldiers is not even capable of violating the CERD makes no sense. Indeed, it's a curious thing for Azerbaijan to take the position that our claims for hate speech are capable of falling within the scope of the CERD, but when that same speech is used in the midst of violent attacks against defenseless persons, or torture of them in prison, or disappearing of them, then suddenly the speech has nothing to do with racial animus. Second, the assertion that the violence inflicted on Armenian soldiers, captured so well in the horrific videos that we have placed on the record, can only be understood as the natural product of their combatant status, equally makes no sense. Yesterday, Mr. Talman referred to Azerbaijan's military trophies park. Well, we should ask, do belligerents normally construct such a public park, depicting enemy soldiers in humiliating positions and with exaggerated facial features, which clearly play to racial tropes? No, they do not, but Azerbaijan did. The court will recall that this park was opened by President Aliyev himself. But then, as Mr. Salonides noted, these racist mannequins were quickly withdrawn by Azerbaijan in the midst of the court's first provisional measures hearing in this case. In doing so, what better admission could there be on the part of the respondent that its attitude towards Armenian soldiers was not motivated by typical animosity towards a belligerent, but rather was motivated by racial animosity prohibited by the convention? And do normal belligerents seek to educate their children to believe in these racial tropes? No, they do not. But Azerbaijan did. The creators of these racist caricatures of ethnic Armenian soldiers, seen on the right of the screen, proudly proclaimed, and I'll quote, "We tried to create the ugliest images. We usually try to do something beautiful, but now it was the other way around. It was a long and difficult process. We gave them hooked noses, flat heads, and other features." And do normal belligerents, as part of an armed conflict, have soldiers who wear patches that say, "Armenian, don't run. You'll die anyway, just exhausted"? No, they do not. But Azerbaijan did. And finally, do normal belligerents, after the armed conflict, adopt postage stamps depicting a soldier/exterminator cleansing a people from the region where the conflict occurred? No, they do not. But Azerbaijan did, and these stamps were so egregious that the Universal Postal Union declined to register them. Acts and attitudes like this are not the natural product of a belligerency. But the important point is that, given the circumstances, these acts against these soldiers cannot only be understood as the natural byproduct of war, but they can be understood quite easily as acts capable of violating the CERD. To sum up on this first point, Mr. President, all of Armenia's claims concern conduct capable of breaching rights protected under the CERD, thereby falling within its scope, even if the conduct at issue also implicates IHL. Mr. President, members of the court, I turn now to my second point, which is that the general Armenophobia espoused and cultivated by the government of Azerbaijan is a relevant factor in determining whether the conduct at issue in this phase is capable of breaching rights protected by the CERD and thereby falls within its scope. Azerbaijan seeks to dismiss the general Armenophobia as mere background context when considering whether violent acts, inhumane detention, and enforced disappearance of ethnic Armenians, many of whom are still missing as of today, are capable of violating the CERD. Instead, Azerbaijan insists that evidence of racial animus expressed in conjunction with each individual act is required. Now, as it happens, Armenia has presented abundant evidence, direct evidence, of the racial motivation behind each and every claim we have asserted. But here is why the general Armenophobia, espoused and cultivated by the government of Azerbaijan, is also relevant. Such Armenophobia is part of a seamless tapestry that trickles down to the facts of violence, inhumane detention, and enforced disappearances upon which Armenia's claims are based. As such, this general Armenophobia further helps to explain why the facts we have presented, if taken as true, are capable of violating the CERD. It helps explain why racial animus was expressly articulated when much of the conduct occurred. It helps to explain why implying racial animus to other comparable conduct is appropriate. And it helps to explain why such racial animus happened on a widespread basis. As a prelude to the presentations to come by Ms. McDonald, Mr. Klingler, and Professor Sicilianos, consider the following sampling of the facts in the record, which demonstrate official racial animus towards ethnic Armenians by Azerbaijani officials at the highest level. President Aliyev has repeatedly characterized ethnic Armenians as bandits and vandals, fascists, wild beasts, predators, jackals, and a wild and savage tribe. President Aliyev has also declared Armenians of the world to be Azerbaijan's main enemies. In fact, President Aliyev promised that the Azerbaijani army would chase Armenians out of Nagorno-Karabakh like dogs, a phrase that, as you will hear later from Ms. McDonald, was adopted by the Ministry of Defense, who then used this derogatory term through servicemen while committing atrocities against ethnic Armenians. Azerbaijan's former deputy prime minister and then mayor of Baku explained to a German delegation, and I quote, "Our goal is the complete elimination of Armenians. You, Nazis, already eliminated the Jews in the 1930s and 40s, right? You should be able to understand us." End of quote. The Committee of International and Interparliamentary Relations of the Parliament of Azerbaijan has also referred to Armenia and the Armenian diaspora as a cancerous tumor of Europe. And just this last month, as our agent previously noted, President Aliyev referred to the lighting of a bonfire in what he called the liberated lands of Nagorno-Karabakh as also doing the final cleaning. Such statements by Azerbaijan's highest level officials, including those explicitly directed at Armenians of the world, are clearly ethnic in nature. They are not directed against a specific country or against the nationals of a specific country. And Azerbaijan cannot hide behind such statements as mere private speech. The extensive facts in the record reveal that this ethnic hatred is state policy instilled in ordinary Azerbaijanis through Azerbaijan's media and its education system. Freedom House, which ranks Azerbaijan as not free, has noted how the Azerbaijani government, and I quote, has cultivated a policy of extreme hostility toward ethnic Armenians with educational, cultural, political, and military components, end of quote. But it goes on, including the Azerbaijani school curriculum, which is, I quote, known to include negative and discriminatory references to Armenians, end of quote. This overall racial animus, which includes glorifying violence against ethnic Armenians, inescapably led to the atrocities that lie at the heart of these proceedings. Indeed, the facts show that Azerbaijan's murder, torture, and other brutality, arbitrary detention, and disappearance of persons was not uniquely directed at Armenian soldiers, nor uniquely directed at Armenian nationals. It was also directed at persons that Azerbaijan regards as its own nationals, no matter their age or whether they took part in the hostilities. As such, the facts show that Armenian ethnicity was not simply a collateral or secondary aspect of harms directed at soldiers of Armenia or at nationals of Armenia. Rather, if the facts are taken as true for purposes of this phase, as they must, our facts demonstrate systematic and relentless policies of racial hatred against ethnic Armenians regardless of their nationality, which were unleashed at highest levels of the Azerbaijani government and then worked their way down into the conduct of the average Azerbaijani soldier and citizen, leading to the atrocities against ethnic Armenians. That such animosity was directed against all persons of Armenian ethnic or national origin, and not just at Armenian soldiers or nationals, is clear from the concluding observations on Azerbaijan reached by the CERD Committee in 2022, which are found at tab 2 of your judge's folder. In its presentation yesterday, Azerbaijan portrayed the committee's observations as irrelevant, no doubt because they are quite damaging to its position. Yet the committee is the body specifically tasked with monitoring the compliance of states with the CERD, taking into account information received from a variety of sources, which in this instance included Azerbaijan's own reports and presentations. After doing so, the committee reached important conclusions and recommendations, which, though not legally binding, are nevertheless highly relevant for understanding if the conduct at issue, in this case, is capable of violating the CERD. Thus, at paragraph 4, you will see that the committee said that it was deeply concerned about, and I quote, subparagraph A, allegations of severe and grave human rights violations committed during the 2020 hostilities and beyond by Azerbaijani military forces against prisoners of war and other protected persons of Armenian ethnic or national origin, including extrajudicial killings, torture, and other ill treatment and arbitrary detention. And then at subparagraph C, they are deeply concerned about incitement to racial hatred and the propagation of racist stereotypes against persons of Armenian national or ethnic origin. Such deep concerns are not referring to acts directed against the country of Armenia or against Armenian nationals. You can see quite clearly from some paragraphs A and C that the CERD committee is concerned about racial animus against protected persons of Armenian ethnic or national origin, whether related to armed conflict or not. Accordingly, the committee in 2022 issued a series of recommendations to Azerbaijan, 2 of which are now on your screen. Notice how recommendation A is directly speaking to the need for Azerbaijan to do better, to investigate violations of the rights of POWs and other protected persons of Armenian ethnic or national origin, including as it relates to enforced disappearances, torture, and other ill treatment and arbitrary detention, as well as the destruction of houses, schools, and other civilian facilities perpetrated by Azerbaijani military forces in the context of the 2020 hostilities and beyond. Notice further how recommendation D speaks to hate speech, incitement, and promotion of racial hatred and discrimination, including by officials and public institutions targeted at persons of Armenian national or ethnic origin. There is no sense in which these recommendations are limited to the country of Armenia or to Armenian nationals, and every sense in which they express deep concern about conduct against ethnic Armenians that is capable of violating CERD rights, whether related to armed conflict or not. In short, as my colleagues this morning proceed to discuss specific categories of wrongful conduct, whether it be murder, torture, arbitrary detention, or enforced disappearance, this backdrop of general Armenophobia that I have described must be kept in mind, as it informs whether Azerbaijan's acts were capable of being racially motivated and thus fall under the CERD. Mr. President, in the face of this overwhelming evidence of racial hatred underpinning the atrocities committed by Azerbaijan, Azerbaijan insists that our approach would prompt parties to other armed conflicts to bring their claims before the court under the CERD, despite the lack of any real connection to racial discrimination. We disagree, given that Azerbaijan's conduct constitutes racial discrimination of a kind rarely seen in recent human memory. But consider as well the result of Azerbaijan's preferred approach. Any party to an armed conflict could commit unspeakable, racially motivated abuse against soldiers and civilians alike, and yet not be held accountable under the CERD. Azerbaijan also insists that every incident of harm, the detainee who is murdered, the internee who is beaten, the civilian who has disappeared, must be associated with specific evidence of racial animus relating to that incident. Relatedly, Mr. Wordsworth went on at some length yesterday about our claims not involving a systematic campaign or practice. Well, as I've already noted, and as my colleagues will recall in their presentations, Armenia has presented extensive evidence of racial animus related to specific incidents, which is clear from the record. At the same time, one can certainly look at our evidence and reach a conclusion that the conduct of which we complain was widespread or systematic in nature. In either event, I would just make 2 points. First, the plain language of Article 2 of the CERD makes clear that Azerbaijan may engage in no act or practice of racial discrimination, which clearly contemplates that even a single act of racial discrimination is capable of violating the CERD. Here, Armenia has alleged multiple acts that, taken as true at this preliminary stage, each independently violate the CERD, and at a minimum are certainly capable of constituting violations of the CERD. As such, the second objection fails. Second, there's no need for the court, even at the merits stage, let alone at this stage, to adjudicate each and every underlying act at issue. As the court held at the merits stage in DRC v. Uganda, in order to rule on a claim, it is not necessary for the court to make findings of fact with respect to each individual incident alleged. That is no less true in this case. Mr. President, that concludes my presentation. If it pleases the court, this may be the appropriate time for the break. In any event, it is Ms. MacDonald who will continue Armenia's response.
And before I invite the next speaker to take the floor, the court will observe a 10-minute break. The sitting is suspended.